Well, let's get started. My name is Colin Day. I'm a financial advisor with Correct Capital Wealth Management. You all are joining me today for the topic of Estate Planning 101. So thank you so much for joining us. These quarterly webinars generally last somewhere between 20 to 25 minutes, and their intention is to be on one particular topic. So each quarter, we reset the topic to something completely different, from investments to inflation and interest rates and now estate planning. So every quarter, be on the lookout for information from your plan representatives to have this topic. So again, topic du jour is Estate Planning 101. And just some ground rules for the meeting in case this is the first time you've joined us for these quarterly webinars. Again, we welcome everybody here because you're part of our 401k ecosystem. You participate in one of our retirement plans through your workplace. We as financial advisors are here to provide you with information in regards to different kinds of topics. We are not legal or tax professionals. So just to mention that, because we are going to be talking about estate planning, it is good to bring in your professional network to help you understand what your given situation might yield in terms of an estate plan. Today, we'll talk more in generalities about some various topics and some things that you can take to perhaps an estate planning professional to help you with a few things. If you have any questions during the meeting, feel free to put them in the chat and I'll get to them if they are pertinent to what we are discussing at the time. Otherwise, you can feel free to unmute yourself at the end of the presentation when we have a Q&A session. So for today's conversation, again, we're gonna level set at the beginning. We're gonna talk about what is an estate plan, what is involved with estate plans to make sure we're all on the same page. We're gonna talk a little bit about probate and why in general people want to avoid it. We're gonna talk about what happens when you die. Not exactly to you specifically, you could talk to your spiritual leaders. They can give you maybe some direction at what happens when you die, but we'll talk a little bit more about your estate, your investments, and how that works. We'll do some case studies just to give you some ideas as to maybe some things that might bring up some deficiencies in your plan or make you feel better prepared in the case that we need to look at an estate plan. And then we'll talk about your next steps. And again, we'll address your questions at the end. This meeting is being recorded, so just in case any of you do have to drop off, feel free to come back later. We will send the link out. So what is an estate plan? Let's start here. So an estate plan really is a formalized plan that ensures that your assets are going to whom you would like them to go to in the manner that you wish them to go to. And I put this imagery on this slide just to kind of indicate that an estate plan isn't for the uber rich. It is for them, but it's for everybody else as well, because you might only have maybe your 401k plan, maybe your house, maybe a car, maybe a couple other things that might dictate what is enclosed in your estate plan, but it doesn't mean that you don't want those things to go to your loved ones, to go to your favorite charitable organization. We want to make sure that everybody has some kind of estate plan in place that, again, allows you to have control beyond the grave to make sure that the money goes to whom you want it to go to, that your card collection goes to your grandson, whatever it might look like for you. So as examples of things that are included in the estate, including the things I just mentioned, so again, like your home, cars, bank accounts, commonly forgotten, investments, your insurance, personal possessions, and collections. So yes, even the Beanie Baby collection that's in your basement in a trash bag gathering dust is a part of your estate. And if it has some kind of value, or if it can be given to somebody else, it can be included and should be addressed within your estate plan. Probate and why people want to avoid it. So those of you on this call that have been, an executor or in charge of the probate process for a loved one will know what mind-numbing and hair-tearing out situation that can be when you're in charge of it, because ultimately you're kind of left to your state courts to determine what the process looks like. So probate really is just a legal proceeding to administer your assets after you pass. So again, each state, so depending on where you're reaching me, your state has a probate court that has their own process and procedures for basically removing things from one person's name and then spreading it out amongst the individuals or organizations in which the individual who passed away would like to go to. Now, in general, probate is not a short process. It is time consuming. So not only do you have to do work, but then it takes forever for the courts to go through the process of disseminating assets. So in general, it takes a minimum of 6 years, or sorry, excuse me, 6 months, but it could take longer than that. It could take years. For example, there's someone we're engaging with whose loved one passed away well over a year ago, and they are still in the throes of the probate process. Just kind of depends on where you're at, what state you're in, how proficient they are in the processing of somebody's estate. From an expense perspective, why people try to avoid probate is you've got not only attorney's fees, because you're paying an attorney to engage with the court to move things through. You, of course, then have the court fees, because it's not free for those people to work to divvy up the estate. You might have a bond that you have to pay to be able to disseminate the assets. The land that your estate might include might require an appraisal just to understand what the land value might be. And then that comes down to the taxation of the individuals that are receiving the assets, eventually selling them off. It could include things like surveys as well on properties. And of course, executor's fees. So if you're paying a third party, so for example, if I passed away and I had nobody in my family to execute this, there might be a third party executor assigned that might have fees for their time that they're putting into this. So all this is to say is that the probate process can be long, it can be expensive, and it's time consuming. So if there's ways that we can protect the estate or make the probate process as streamlined as possible or as easy to get through as possible, why not take that opportunity? So what happens when I die? Again, we'll mostly refer to investments for this particular conversation. So depending on the different kinds of accounts you might maintain, there's different rules that apply. So again, most of you, if not all of you on this call, are affiliated with one of our 401k plans where we serve as your advisor. So your 401k plan has a beneficiary designation. So, and if this is something you haven't looked at in a while, we encourage you to do that because with the beneficiary designation, that will be the first thing that gets looked at when we think of the divvying of the estate. So it is I'm forgetting the word that I'm looking for, but basically it's the first thing that the 401k company is going to look at, your record keeper, to determine where does this money go to. You can have a beneficiary designation with your 401k, and you can have a completely different statement in a will, for example, and it's going to be the beneficiary designation on your 401k account, which is what the record keeper has on file. That's what they're following. So you could put, for example, your will might name your current spouse, but your ex-spouse might be mentioned on your 401k designation because you never updated that. And well, in this case, they're probably going to follow this one because this is the designation that they have on file. So this is why we always want to make sure that we're updating and looking at things. The same rules apply with IRAs. So if you have an individual retirement account, traditional or Roth IRA, simple SEPs, they all have beneficiary designations. So same rules apply there. Now, if you have a brokerage account, otherwise known as a taxable account or just a standard investment account through TD Ameritrade, Schwab, Fidelity, Robinhood, wherever it is, then you have what's known as a transfer on death assignment. So same kind of concept as a beneficiary, just different wording. Bank accounts, they have what's called payable on death designations. Same ideas, money's just moving over to a different person. And in general, with those bottom two, they're going to avoid the probate process because you have somebody else that this money is supposed to be assigned to. So with your bank account, again, not something that most people will have unless you have a joint account with a spouse. That's probably the most common example, where if I pass away and both my wife and I are on an account, it's just going to go to her. But if it goes beyond that and she passes away, she needs to then update it to include a POD. Now, one thing that we do run into every once in a while is somebody very adamantly saying, well, I want to name my estate as my beneficiary or all my descendants as my beneficiary. The challenge with those types of designations is that you're basically leaving it up to the record keeper to decide the estate, and that's not their job. They're just holding on to the document that says that you wish to have your estate named as your primary beneficiary. But the challenge is that they have no way of knowing what your estate actually is or who is involved with it. And so those types of designations generally result in having to go through the probate process to then determine what is going to be appropriate for you. So we kind of stay away from those designations whenever possible. So, but it is, again, critical to have beneficiaries on your retirement account and review them annually. My personal opinion, reviewing every 12 months makes sense. There are births, there are deaths, there are divorces. All these situations garner a beneficiary designation change. So it's a good habit to get into to look at those at least every year. Now, again, with your bank accounts or if you work through a credit union, make sure that you have a POD on file. Don't just assume that it's going to go to your spouse. Don't just assume that it's going to go to your loved ones, because this is just rife with problems. We want to make sure that the money gets to where you want it to go. Now, a trust, so again, a legal document drafted by an attorney, may help you avoid probate, but you should consult your estate attorney to determine that, because we want to make sure, again, if you're going to name a trust as your beneficiary on your 401k or on your bank account or on your investment account, that's the proper way to organize things. Also, we want to make sure that that trust addresses all the things that may encompass your estate so that we're not missing anything, because anything that's missed will have to go, unfortunately, through the probate process. So let's get to some examples. So we have 3 different case studies here, and we kind of organize this into least confusing probate or estate plan all the way through the most confusing one. So we're going to start with Bill. So Bill is 60 years old, single, no children, owns a home and a car. Pretty simple, right? He's just a very simple example of somebody who probably doesn't think he needs an estate plan, but maybe he talked to somebody and they said, well, maybe you want to consider just some very basic things so that you can feel a little bit more comfortable when you leave this world, that you're leaving your assets to where you want them to go. So for example, in this very hypothetical situation, in this case, his home, his designation, so how he is addressing his home, he's addressed it in his will. So maybe he's decided he's given the house to his favorite niece or nephew, or he's going to, donate it to the city, and maybe they're going to put a park on his land or something like that. His 401k, of course, he put a beneficiary designation on file for that. His bank account, he made sure he had a POD on file. And with his car and the other assets that he maintains in his home, again, those are addressed through his will. So because he's a single individual, Bill probably doesn't care all that much that it's likely his loved ones will have to go through the probate process to then determine how to disseminate things or to interpret the will to help disseminate things. But he may also want to have some kind of control over his life if he's ever incapacitated. So he might have something like an advanced healthcare directive with his primary care physician, so that if he was admitted to a hospital and they share that information across the system, they would know what he wants to do for end-of-life care. So if he doesn't want to be resuscitated, or if he doesn't, want to be seen, in a fragile state or vegetative state, he has the ability to have some control because he has some document on file expressing his wishes that will help his loved ones interpret his situation. So case study 2. So again, we're ramping up the complexity here. Now we got 2 people. We got Jim and Patty, similar ages. They're married. They have 2 kids. They're not quite adults yet. They're teenagers, but they are still dependents in this case. Now, the 2 of them have several investment accounts. Maybe it's through their work and also on their own. They have a mortgage on their home still, and they own 2 cars. So besides everything else that's in the house, that's their basic situation here. So when we are looking at the assets and the designations here, again, similar situation in terms of what we're dealing with, but different solutions possibly. Because again, now we're dealing with multiple people and other loved ones. So for example, like with a home, they may have met with an attorney and they said, well, let's make sure that we have some documents written up. So tenants by entirety just refers to these 2 individuals are married. And so if something happens to one person, the title or the name of the owner of the property is going to shift to the surviving spouse. So if Jim passes away, Patty will become the owner of the home. That's what tenants by entirety means. And then if something happens to both of them, like if tragically they're in an accident and it's just leaving their 2 kids and this home, they might have some kind of living trust that they've designed to then provide direction in regards to, okay, here's who the home goes to. This is who's going to be in charge of our children and their lives so that they can be successful adults in the future. Now, their 401k plan, they decided, again, they're going to name each other as surviving spouse. So on their 401k plans through work, they have each other. Then it goes to the trust. Okay. And I mentioned this here because we get this question quite a lot. If I have a trust, who should I name as my primary beneficiary? Should it be my spouse or should it be the trust? Most commonly, we see the spouse named first and then the trust, because if it goes to the trust, it basically has to go through your interpretation and then monitoring it. For the most part, the designation just goes to the surviving spouse, and then it goes to the trust in case you have dependent beneficiaries in there. Bank accounts, POD, same thing as before. Cars, they have made sure that on the titling of the cars, it's joint tenancy. So again, both Jim and Patty are joint owners of it. So if something happens to one of them, it goes to the other. And then again, they have a trust on there as well as a backup. The life insurance is the surviving spouse and then the trust. So you could probably see a pattern here that they just want to make sure that both of them have the power to work on each other's assets if one of them was to pass, and then the trust becomes the backup resource for them. Now, Jim and Patty also have a will. So you'll notice the will wasn't mentioned in here, but they do have a will, and that's naming their guardians of their minor children. And they also have a durable power of attorney so that if something was to happen to them, they have the ability to act on each other's behalf. They can make decisions for one another. So in Jim and Patty's situation, again, we're raising the level of complexity. And again, I bet there's many people on this call that can probably relate to their situation or similar or something similar to it, where this is essentially the best way for them to, and again, this hypothetical situation, to organize their estate plan. So finally, third case study, possibly the most complex. Now we're blending families together. So Sal is 75, Teresa's 68. Sal and Teresa had a child together who is 30 years old. But from previous relationships, Sal had a child and Teresa had a child. And they're much older than the child that they shared together. So now we're dealing with children from the previous marriage who also have their own kids. So Sal and Teresa's grandkids, and then their child that they shared together. So level of complexity gets more confusing here because Sal and Teresa want to serve, their own children that they had in separate relationships and also the one together, but have to balance everything out along with another level, another generation in their family in the form of their grandkids. So for example, the home in this case is only owned by Sal. Teresa isn't named on it. And that was because he owned it before he met Teresa. So for whatever reason, it's still in Sal's name. And he's decided that it's going to be in his living trust. And for his living trust, it may address his child and grandchildren from his previous relationship. The 401k plans that they have, they may have completely separate beneficiaries. They might, name 50-50 their children from the other marriage, and then the other 50% goes to the child that they share together, as an example. Brokerage accounts, they might use their separate trust to kind of organize the thoughts in regards to where things should go. So again, money is going to the proper parties that they feel is appropriate for them. Their bank accounts have PODs with separate individuals on there. Their car has, again, the joint tendency. So in this case, they are going to be able to operate that vehicle if one of them was to pass away. But again, and then separate trusts depending on the situation. Life insurance could be the surviving spouse for them, and then the trust. They might be setting up something like an ILIT or something more complicated to be able to determine where that life insurance was to go. But again, this is the level of consideration that they have to put together because of the blended family situation. So it's all about making sure that they get their concerns addressed with an estate planning attorney in this case, to make sure that the money that they have goes to the individuals they want, sharing what they feel is appropriate across both party lines, let's say, but then also making sure that their children from other relationships and their grandchildren are also being addressed. So in this kind of situation, it's always recommended to speak to not only your estate planning attorney, but your tax professional to determine the best route. So next steps. So depending on where you identify within those case studies, some of you on this call might identify most closely with 1 or 3 or 2. Over your life, it may change. You might go from a 1 to a 2 to a 3. But the reason we put this out here is mostly just to say that if you haven't thought about it, meet with an estate planning attorney. Buy an hour of their time. And it's not cheap. You're probably going to spend a little bit of money for this, but it might not be a bad idea to at least address some questions with an estate planning attorney so that you feel at least better about your given situation, what you've done already, or if you feel like you need to make some kind of update to it. Simple enough, it would be to make sure that you have reviewed your beneficiary designations, not only on your 401k accounts, but on your other investment accounts and bank accounts annually. So it's just making sure that you've got it on paper. It's the people that you want on there, and whether you see that form or you update it, you send a new form every year, or just make sure that your online account is updated. Whatever makes you feel fulfilled and happy that you've done something. And then finally, we want to make sure that you store copies of documents in a place that your loved one will find them. And for like my parents, they put a lot of their documents in a little envelope on the fridge. I think they got from AARP or something like that years ago. For others, it's, the lockbox at the bank, or, at their attorney's office. Again, if it's healthcare related, it might be with the primary care physician. But making sure that you share this information, if applicable, with your loved ones, your spouse, or with your kids or grandkids for that matter. Having multiple copies in different places, not a bad idea, but it's making sure that everybody knows where the information is so that when the inevitable does happen, they have some place to go and know that your last wishes are being met. All right, well, let me pause there. So again, this is very general conversation about estate planning. These are really some quick hitters. The case studies, I had to be a little bit careful because, again, these are all hypothetical situations, and every estate planning attorney is going to have a different interpretation of your situation, and the results will vary, of course, then as to what kind of documents they'll suggest for you. But this whole idea of this webinar is really just to give you some ideas in regards to what your in-plan might look like. And again, if any of those situations resonate with you, we'd encourage you to reach out to an estate planning attorney, or if you have some general questions and I can point you in the right direction, you can feel free to ask them. So I'm going to take a quick water break, and let me know if you have any questions. Again, if it's easier for you to type in the chat, go ahead and do so, or feel free to unmute yourself. Okay. Well, I hope this means you have all the answers, or my presentation was at least adequate enough to tickle your fancy and think of some other things that you'll look at in the future. So if there are any questions that you want to address, maybe not in a group setting, you're more comfortable just working one-on-one, my email address, my phone number are right there. John Biedenstein's another advisor in our group who could address some of your questions or concerns as well. So we are here to be resourceful to you. We might not have all the answers, but again, we're more than happy to at least point you in the right direction. So I'll give another 30-second pause to see if there's any questions.
I just want to thank you for your presentation. It was very informative. Appreciate it.
Great. I'm very happy to hear that. Thank you so much. And again, if anybody missed any portion of the presentation, this is being recorded and we'll distribute this out to how you got to this link in the first place. All right. Well, without further ado, thank you so much for joining me today on a Friday afternoon. Here in St. Louis, it's absolutely beautiful weather outside, and I hope it's the same for you wherever you might be catching this. And until next quarter, when you see this webinar coming through again, we'll talk next time. All right, thanks everyone.